may have heard me argue that the judge didn't follow those steps. So he denied my motion. I asked him if I could appeal that to the Court of Appeals immediately, and he denied that. I suggested that there was a bit of a cloud hovering over the case because of the situation, and he took offense to that and warned me to tread lightly.
The court's basis for having been explained on the record, a written order of this, along with the attachments, will be included in the record. And Mr. Banks, where are you? Sir, as a result of this transcript release, the court withdraws the show cause for your client and others who may be present who are present in chambers on the 10th of June of 2024. And as I mentioned earlier, we were going to have a show cause hearing on Wednesday, the 3rd of July. I am canceling that indefinitely.
Wow.
So we will not be holding that particular hearing, okay?
Wow, Kayla is not going to jail, guys. She's not going to jail.
And then then transitioning to the last matter the court wanted to put on record. Upon further review, this court will in fact enter an order sending Mr. Adams and Steele, Mr. Weinstein, and Mr. Banks motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So this written order is entered. I will enter the order transferring it. And until such time as those two things are decided, then we'll be in recess until that time.
Oh my God.
Wow. What do you think about that?
Well, as you know, ain't nobody got time for that.
Again, Miss Bumpus. But if he says he don't recall to everything, he'll be okay? Miss Hilton, I'm not advising that. But so long as he answers the questions, that's fine. So long as he, little Woody, I did these crimes. I'm telling you that.
I did these crimes.
Miss,
I did these crimes. Oh my God. Atlanta is fucked up, guys. I don't know what to tell you. Atlanta is fucked up. This is crazy. I did these crimes.
I'm telling you that.
Oh my God.
Hi, everybody. Welcome back to the AV to the 7th Power channel, where we talk about all things law, crime, and debauchery. Today, we have an important update on the YSL trial, covering the latest developments from this week. And before we go anywhere, please check out the sponsor of today's video, Aura. If you want to protect your data, your privacy, your credit, and stop robocalls, please check them out. You have a free 14-day trial using my code below. Let's get into it. The week started on a somber note with tragic news of Tay's passing. Tay, an individual named by Little Woody during the police interrogation footage, who later recanted his statements on the stand, was taken down by gun violence early Saturday morning in Atlanta. Police are currently investigating the crime, and our thoughts go out to Tay's family and friends during this difficult time.
Deadly shooting in southwest Atlanta happened early this morning at an apartment complex. Channel 2's Brian Mims is live on Peyton Place. Brian, police say the shot was fired from outside of the apartment.
Exactly, and police say they don't have many details about what led up to the shooting, but there is a big police presence here at Peyton Place, just off Martin Luther King Jr. Drive. You can see the officers still on the scene after more than 3 hours. The call came around 3 this morning, and when officers showed up at an apartment at 9 Peyton Place, they found a man in his early 20s who had been shot to death. It's unclear if anybody else was inside that apartment, but police say there were no other injuries.
In court on Monday, Judge Glanville, who had initially scheduled a review of the ex parte transcripts by the defense attorneys, made a significant and unexpected announcement. Instead of a limited review, he made the full, unredacted transcript available to all. This decision followed a writ of mandamus that went to the Georgia Supreme Court and was later redirected to the Georgia Court of Appeals. The Georgia Court of Appeals indicated that the court would review the matter of Judge Glanville's potential recusal from the case and assigned it to a new judge. The trial will be paused until this issue is resolved. And let's stop for a minute and define exactly what a recusal is. According to Black's Law Dictionary, a recusal is defined as removal of oneself as a judge or policymaker in a particular matter, especially because of a conflict of interest. Defense attorneys have argued that the ex parte meeting was legally improper, given that none of the defense counsel was afforded an opportunity to attend. Later that Monday, I had an opportunity to interview Doug Weinstein, a defense attorney representing one of the defendants.
I went to the judge at the end of the day, and I filed a motion and I gave it to the judge, and I asked the judge to recuse himself from the case. And there's certain steps when that's done. There's a process in the rules here in Georgia of exactly what has to happen then. So, for example, when I asked the judge to recuse himself, he's required to stop doing everything he's doing. And he has to see, well, is the motion filed in a timely fashion, which it was because it was within 5 days of what I was complaining about, which was the secret meeting, the ex parte meeting. In the affidavit, the document that I filed where I provide the allegations of what happened in that meeting and why he should be recused, does that, where the I's dotted, where the T's crossed on that affidavit? And if you read the affidavit and you assume everything I wrote is correct, should he recuse himself? And if the judge goes through that process and says, yes, I'm not going to argue with the facts because I'm not allowed to, but if everything you say is true, then perhaps I should recuse myself. And therefore, I, as the judge, need to have another judge determine whether I should be recused. Recused just meaning being removed from the case and another judge taking over. So I did that, and I don't believe the judge followed those steps. And some of you may have heard me argue that the judge didn't follow those steps. So he denied my motion. I asked him if I could appeal that to the Court of Appeals immediately, and he denied that. I suggested that there was a bit of a cloud hovering over the case because of the situation, and he took offense to that and warned me to tread lightly.
Later that evening, we learned that Doug filed a motion for the new judge to recuse herself as well, requesting that the case be reviewed by a judge from another county. This move aims to ensure impartiality and fairness to the defendants in the trial. Brian Steele, Young Thug's attorney, filed an attorney proffer to officially document the ways in which Young Thug's constitutional right to a fair trial has been violated. The issues range from improperly hampered cross-examinations to various complications involving Little Woody. The lead attorney and I also had a chance to speak with Kayla Bumpus, the lawyer who represented Little Woody in the ex parte meeting. We gathered her thoughts on the newly released transcript, shedding more light on the proceedings. On Tuesday, the lead attorney and I carefully parsed through these documents together. Our deep dive into the transcripts and filings revealed the intricate details and complexities of the case.
But what we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your questions is how you answer your questions. I know what you said before, and I know what you said later. I know what you said before, and I don't know what you're going to say on the stand, because you and I never went into full details about any of it. But what I don't want is you to be sitting here in custody. Little Woody, you did it. Miss Hilton, I did not do it. You did it by pleading the fifth. Little Woody, you told me before you went to the judge with whatever the thing you called, we went with him with, you told me that I can't, when I'm asked a question, I could say I don't recall or I don't know. You told me if I plead the fifth, something, why would I plead the fifth to something I ain't do? And I said, you don't know what I did and what I ain't do. And then you was like something. And
Wait,
then
let me stop right here. We've been making fun of Little Woody all the time for this I don't recall. Is he saying now that damn Attorney Hilton is the one who gave him that answer?
He did it again later in it.
That's crazy. Hilton herself just said, I don't recall. Hilton is, and the defense attorneys aren't even in the room.
Yes,
He is counseling his testimony. This is outrageous. She is telling him what to say on the stand. And the defense attorney they're not even in the courtroom.
And we're only on page 30.
You told me when I'm asked a question, I can say, I don't recall. Man, and that he said, I don't recall 1,000 times.
He did.
Jesus Christ. All right, let's keep going. This is insanity.
And then y'all asked me for this immunity. And I was like, it was something. And then Thursday or Friday came. And then y'all go tell me, oh, we want the judge. We went to the judge with this. So you got to testify. If you don't testify, the judge gonna lock you up. Miss Hilton, right. But that was based upon you, Little Woody. But I told y'all that. Miss Hilton, no, you didn't. Little Woody, you said, why would I plead the fifth to something I ain't do? I said, you don't know what happened, Miss Hilton. And I said, I don't know what happened. Only you know and them know, I said. But you never said, am I pleading the fifth? You said, what if I do this? What if I do this? What if I do this? Little Woody, I told you, I said, I'm going to plead you said, why would you plead the fifth to something that you know you ain't do? Miss Bumpus. So if you didn't have immunity prior to, is this what you are saying?
Wait, I see what Little Woody's saying.
Yeah.
Because Little Woody is saying, I told you I'm going to plead the fifth. Mm-hmm. And she says, you didn't tell me that. You didn't tell me that. And so he does it the other way around. He says, well, you asked me a question. You asked me, you said, well, Mr. Copeland, why would you plead the fifth to something that you didn't do? Think about it. What would I have to say for your response to be, why would you plead the fifth to something that you didn't do? What would I have to say so that you in turn would follow up with that? Why would you plead the fifth? Obviously, if you're asking me, why would I plead the fifth to something that I didn't do? It's because I said initially, I'm going to plead the fifth. I'm going to plead the fifth. And then you respond, why would you plead the fifth to something that you didn't do? I mean, he's kind of using the reverse psychology a little bit. He's trying to show him the other side. Mm-hmm. You know, sometimes it's cause and effect, but sometimes you got to look for the effect to see the cause. Little Woody, he is a little savvy. Little Woody, he's very savvy. Sophistication. All right.
Savvy.
So start again right here.
Mr. Little Woody said, I told you, I said, I'm going to plead you said, why would you plead the fifth to something that you know you didn't do, Miss Bumpus? So if you didn't have immunity prior to, is that what you are saying, that you feel like he didn't have immunity prior to? Little Woody, immunity came Friday, right when I went to jail. Miss Hilton, the immunity only came after Mr. Melnick. Miss Bumpus, hold on. Miss Hilton, the immunity came after Mr. Melnick sent us an email saying, my client is pleading the fifth. That was sent on Thursday evening at 6 p.m. Miss Bumpus, okay. Miss Hilton, so after that was the empathic. He is pleading the fifth.
One major update from Tuesday was that the Court of Appeals had given the prosecution a deadline of this upcoming Monday to respond to the initial motion. This deadline sets a crucial timeline for the next steps in the trial.
With or without Miss Bumpus, I'm here, Little Woody. But we do not want you in custody. We will not. This order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution, Little Woody. Any of it. Literally, Judge, you might want to close your ears. Simone. Judge, you might want to close your ears. If you confess to a murder on the stand and we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution from what you say in court.
The sex party meeting should have never taken place. When I filed my recusal motion, as I said to Judge Glanville in court, Judge Glanville didn't follow the procedures. So having someone of that weight weigh in with their affidavit, I think was tremendous and more valuable than anything I wrote in my motion.
Yeah, it was. It really was. And with this audience, I had an opportunity to go through the first few pages with them on the lead attorney side. But as I looked through the affidavit, I was just like, wow, this is interesting. I love that this was included. But then, I really took the time to go into Lester Tate's background, his experience, his training, and really get the audience to get to know, like, hey, this is a heavyweight here weighing in on this. And there's a big difference between, because I think Judge Glanville said this, the orders, right? His rulings, but also his conduct.
Right.
So we underlined that 100% because I wanted the audience to walk away and understand that.
I'm so glad you educated your audience on that, because Judge Glanville misrepresented what I had in my motion in court.
Yes.
I never, ever complained about his rulings or his orders. I was complaining about conduct, and conduct that I maintain based on what I learned, assuming that what I learned was correct, was in violation of the Judicial Code of Conduct. And it's conduct that merits recusal. So I was taken aback, honestly. I don't know if you could see my reaction in court, but I was surprised that he would mischaracterize what was in my motion in that way, especially because anyone watching would not know what was in the motion.
Exactly.
There's no complaint in my motion or in my affidavit about anything other than conduct. And then to have Lester Tate weigh in and also make that distinction was really important. If I wanted to file a motion to recuse every time that I was unhappy with a ruling from Judge Glanville, well, we could have done that hundreds of times. I don't have
especially over these few months,
Yeah, I would never ask him to recuse based on rulings. I would only ask him to recuse based on conduct.
That's all for today's recap. Make sure to stay tuned to the AV to the 7th Power channel. Thank you so much for watching. Don't forget to like, share, subscribe. Let me know what you think in the comment section below. Stay safe out there. See you in the next one. Bye.